Bryan Kohberger received 4 life sentences after pleading guilty to murdering 4 University of Idaho students. But in his first interview with media, he says he wants to take that plea back. The convicted killer told the New York Times he filed a petition to reopen his case and challenging his conviction. Kohberger blames his previous plea on what he calls, quote, false promises and blatant disinformation. He's currently serving 4 consecutive life sentences for the murders, despite claiming he's innocent. In documentation submitted to the court Monday morning, Kohberger bases his application for relief on ineffective assistance of counsel, also citing the failure to review or disclose exculpatory evidence and by sharing, quote, elaborate lies as to the conditions on death row. In a social media statement about this development, the family of Kaylee Gonzalez calls Kohberger the mosquito you can't swat. They write in part, quote, he did this after deciding not to leave his fate and the facts of the case up to a jury to decide his guilt. He never cried wolf or claimed he was uninformed, pressured, or that there were issues with the discovery that he and his counsel had for 2 years that he thought should have been challenged. He admitted to guilt and asked whether he actually was guilty. He said yes, end quote. To break down how this could work or even be possible, we're joined by attorney Ann Brimner. Thank you for being here again, Ann.
Thanks. Nice to see you.
Nice to see you, too. Well, to start, as part of Bryan Kohberger's plea deal, he waived all rights to appeal. So how is this possible, and what options does he really have?
Well, it's possible, but it's not probable that anything will happen in his favor. I've said before, there's like 3 things in life that are certain: death, taxes, and you can't withdraw a guilty plea. I mean, that's how solid a guilty plea is, especially with him. He had 4 lawyers. He had all kinds of discovery, all kinds of time before the trial. And you can't withdraw a guilty plea unless there's something called manifest injustice. And that has to be a clear error, a clear problem, something that manifests that happened here that we can look at and say, you know what, that was completely unfair. For example, he didn't have a lawyer. Well, he did. Or, for example, he didn't finish the plea form and he wanted to not plead guilty, but they said he had pled guilty when he didn't. Just things like so obvious of an error. And that's the only way he can do it. He's filed his own paperwork and he's basically saying the lawyers misled me. He's very amorphous about it. He doesn't have anything, like you said, he says it's exculpatory evidence, but what is it? He says they misled him. How did they mislead him? By the way, if he comes back to trial, assuming he gets his desire, which he won't, then he's facing the death penalty. He's facing a firing squad. And he acknowledged that to Mike Baker at the New York Times. I mean, I shouldn't say crazy, but how misguided is that?
Well, and on that note, is this a commonly filed petition? How often does something like this happen in these high-profile cases?
You know, because he's somebody that thinks he's smarter than everyone else. You know, he's a PhD in criminology, you know, all this education, advanced education in criminology. He thinks he can basically do his own thing. But you also see people pro se, which is representing yourself, filing petitions like this. Are they successful? We saw it in Menendez brothers. We see it in a lot of big cases. Rarely are those successful. But it's something that they can avail themselves to. The question is, will a judge grant an evidentiary hearing? Will it go that far? And I think the answer is no.
Well, as you mentioned, Kohberger hasn't quite yet presented any new evidence, but says he wants his questions and issues to be answered during a trial. So my question to you, could there be more evidence in this widely covered story, or do you think this is more of a last-ditch effort? What's your personal opinion there?
Oh, I'll tell you what mine is. It's the last-ditch, you know, Hail Mary, but, you know, anything he can do. He must hate it in prison. I mean, anybody would. But he's basically saying that his lawyers were inept. He had the top defender, Ann Taylor in Idaho, and 4 really great lawyers. He had years, you know, of discovery. He was given everything. And I think the families, I think when they look at this and say, what about us? You know, what about us? He gets all of this attention. And, you know, if he wants to come back and have a trial and get the death penalty, you know, maybe some of the families actually would welcome that they wanted the death penalty and were upset about the plea bargain. So if that's what he wants, that's what he may get.
Well, on that note, what's next? How long could this process take and play out?
You know, it hasn't been noted for a hearing. The judge hasn't agreed to an evidentiary hearing. The other side is going to respond within about 30 days. And they've already said, you know, that they will be responding. And they're going to basically come out and say there's no basis for him to get to withdraw his guilty plea, and it may be just ending with that. I mean, and it's like enough already. It's just too much in a case that's been so horrific. I think what people really wanted was when he spoke at his plea hearing, they wanted him to say what happened. Why didn't he just say what happened? That's what people want, and that's what he needs to do, but not withdrawing a guilty plea under any circumstances.
Ann Bremner, thank you for your expertise. We appreciate
My
your
pleasure.
time.
Thank
All
you.
right.